there because I think it's important to distinguish what I would say is the difference between the Booker holding and the right that is recognized, the newly recognized right. Booker's application, the Supreme Court ordered retroactive application of the Booker holding, which tells us that they are acknowledging that there's a newly recognized right. And I point the court to page 68, which is the very end of Justice Lee's opinion, in which she says, Mr. Booker writes, Mr. Booker committed a serious offense for which he deserves serious punishment. But he was only 16 years old when he committed the offense. The United States Supreme Court has made clear that under the Eighth Amendment, youth is a factor that must be considered in sentencing. And that's the newly recognized right that I'm arguing exists.
I understand. Now, how does that apply to this case where the guy pled guilty to an agreed-to sentence?
I knew that would be the next question. So it applies to Mr. Mason, first of all, because he was facing the possible imposition of that mandatory life sentence. And when we look to the underpinnings of how the Booker court got to that right, the right to have youth considered, this is what they write in the opinion. Page 60. Although this case involves a life sentence and not death or life without parole, 3 essential rules can be derived from the Thompson, Roper, Graham, and Miller line of cases when considering proportionality. The first principle is that the Eighth Amendment's requirement of proportionality means that punishment has to be graduated and proportioned. The second principle is that steps must be taken to minimize the risk of a disproportionate sentence when juveniles are facing the possible imposition of a state's harshest punishments.
Okay, so let me put this in context.
Mm-hmm.
Your client was 14 years old when he committed this murder.
Yes.
And he was indicted for first-degree murder. And the facts are bad. And the state entered into a guilty plea to a lesser offense at a higher range.
Yes.
And obviously, he benefited from that because he wasn't looking at life. And it seems to me that they took into account his age, the state did, when they made this offer, because it was a pretty good offer based on the facts and circumstances. It's a lot of time, but it's a lot less time than life.
Well, I think that is...
Like 20 years less.
It is 20 years less than a sentence that's no longer possible for him.
But how in the world, I mean, I guess looking at when he entered this guilty plea, and again, unlike Booker, this was an agreed-to sentence. The court could have accepted it or rejected it, but it didn't have any authority to change the terms if it was agreed to among the parties. It could only accept it or reject it. So these terms were agreed to by the parties. It wasn't a situation where the court had discretion and could consider all these factors in setting punishment.
Which is very much like the Booker life sentence, where the court has no discretion.
But the difference is this was an agreement between the defendant and the state.
Yes, but I would say it is an agreement between the defendant and the state that, with the holding in Booker, we now know is an agreement to an unconstitutionally long sentence.
On a life sentence.
And a sentence that was not reviewed, where youth and Mr. Mason's mitigating circumstances of youth were never considered. And that's why Booker applies to him. What we have now, post-Booker, Mr. Mason is serving a sentence that is 10 years longer than what youth in similar circumstances could today receive.
That's assuming they get parole. There's no guarantee you'll get parole.
That's true. There's no guarantee of parole, but he gets the opportunity at release up to, at a minimum, or at 25 years, just 10 years less than Mr. Mason, who will never get the opportunity for a hearing where his youthful circumstances are taken into consideration. Now, Judge, you asked whether or not did the state take that into consideration. Well, that's making some assumptions that are not in the record. We can't assume that that is why the state made the plea bargain offer that they did.
It's a pretty good offer under the circumstances, though.
I would say at the time, Mr. Mason did not think so.
Well, I know that, but
he was faced with 2 options: an option of going to trial and facing a real imposition of a 51-year automatic sentence, or taking a plea bargain that was 10 years longer than what he could have received if he were convicted of second-degree murder. And he had no options by which he could go to the court and say, I want to plead guilty. I don't want to get a 51-year sentence, but I want the court to take into consideration the circumstances, mitigating circumstances of my youth. The court is right. The rules of criminal procedure don't provide for that. And that is part of our argument for why Mr. Mason has suffered a violation of his constitutional rights with the entry of this plea and the service of this sentence, for which he is entitled to relief. Again, like as in Mr. Mallard's situation, he filed a post-conviction petition. It was denied, summarily denied by the trial court. And what we are here asking the court to do is to reverse that decision and allow Mr. Mason to have an evidentiary hearing where he can put on evidence to support his claims and pursue relief in that regard.
What choice did the trial judge have in this case other than to reject the plea and set it for trial or accept it?
Those would have been the only choices that the trial judge had.
So how can the trial judge interpose the defendant's youth into the sentence?
He can't, and that's the problem. That's the constitutional violation of the way the sentencing scheme is set up.
So you're saying that with a youthful offender, there can't be a guilty plea, or the guilty plea has to be without a recommended sentence, and that the court then has to have a full sentencing hearing to determine that person's sentence? Because that's the only thing I see. Because if you enter into an agreement, the court's not going to be involved in making that assessment. It's going to either accept or reject the plea. So what is your suggestion?
Well, I'm not suggesting going forward. What I am saying is that what happened to Mr. Mason when he entered his plea violates his rights under Booker, as newly recognized under Booker. The trial court did not have any discretion to...
In Booker, though, the court didn't set aside his conviction.
Correct.
The remedy, which I think is pretty unique, is that it says, well, you can have a parole hearing.
Correct, and that's a remedy that's never going to reach Mr. Mason.
Okay, so what if the Supreme Court says they're not going to overturn the conviction is not going to be overturned? So so Mr. Mason's going to get different relief under Booker?
Well, I think that is, again, something to be fleshed out in an evidentiary hearing and in the trial court. But I think it's not that the relief may very well be vacating the plea. The relief very well may be vacating the plea and putting him back to the position he was in before he pled guilty.
Well, I'm just saying, in Booker, they did not set aside the conviction. They said the conviction was fine.
Yes, but of course that was a trial. And
this is an agreed-to plea.
This is an agreed-to plea. And what Mr. Mason is arguing, and his position is that plea violated my constitutional rights. And I didn't knowingly waive those constitutional rights. And I think the remedy in the trial court, if Mr. Mason prevails, is likely vacating his plea and putting him back in his original position. And I want to say, I think, going back to the language in Booker, that the second principle is steps must be taken to minimize the risk of a disproportionate sentence when juveniles are facing the possible imposition of a state's harshest punishments. Here, Mr. Mason was facing the possible imposition of a 51-year life sentence if he went to trial and he was convicted.
Well, maybe more than that, because he also had especially aggravated robbery. Also, I think the state dismissed as
an
part of his
attempted, especially aggravated robbery. Yes, Your Honor.
So that was a Class B felony that he could have had either consecutive or could have been concurrent, but it would have been, he was looking at 8 to 12 years on that, so that could have been additional
Yes.
time.
So
And as part of that plea, that was dismissed.
That's correct. So he was facing that, and his only other option and he had an option. The option that was presented to him was to plead guilty and accept an out-of-range enhanced punishment of 35 years. So we're not talking about a situation here where he agreed to plead to second-degree murder and take a 25-year sentence. He took an enhanced sentence, which is now 10 years longer than what anybody convicted, any range one offender convicted of second-degree murder could get in Tennessee. It is 10 years longer than what his potential parole eligibility would be had he gone to trial, been convicted of first-degree murder, and was now serving a life sentence. And he would have gotten the relief that Booker provided for the first-degree murder sentences. And I think the reason that I wanted to go back to your question is there is a difference between holdings and rights, right? And what we are here today arguing is that Booker recognized the fundamental right for youth who are facing the most serious punishments that this state can offer that there is a requirement that their youth be considered in sentencing them. And the process, the scheme that is set up for sentencing in Tennessee in 2008 and even today doesn't really provide for that if youth enter a guilty plea. It didn't provide that for Mr. Mason. And that's the issue for us. It's not about what happens with all the other youth going forward, but for Mr. Mason, he did not get his right. His right was not realized. It was violated. And he is seeking now to withdraw that. And that's the difference. Although the holding, yes, it applies to the factual scenario that was presented by Booker. Mr. Booker went to trial. He was convicted, received a life sentence and a concurrent sentence for his especially aggravated robbery. But I think what the court is recognizing in this language is all of these things are talked about in the concepts of life sentences, life without parole sentences, at one point death sentences related to juveniles. It is the underlying right that is what we're concerned about here and what applies to Mr. Mason. And the remedies that were fashioned for Mr. Booker doesn't touch Mr. Mason. It doesn't provide him with a remedy. And I do want to speak to what the court does say about that remedy, because I think it goes to the importance of having youth considered. They go on to say, again, back to page 68 at the end of the Justice Lee's opinion. She said, under this statute, Mr. Booker remains sentenced to a 60-year term, but is eligible for, although not guaranteed, supervised release on parole after serving between 25 and 36 years. In line with Montgomery, Mr. Booker will, at the appropriate time, receive an individualized parole hearing in which his youth and other circumstances will be considered. It didn't say may be considered. It said will be considered. And so the court is finding there that youth, when they are facing these serious punishments, are entitled to have their youth considered. It must be considered. And the sentencing scheme in Tennessee, the plea bargaining system, the sentencing structure in Tennessee in 2008 when Mr. Mason pled guilty did not provide for that. That violates his constitutional right as recently recognized by Booker. And that's why this case applies to him. That's why Booker applies to him. I think the other argument that we are making, that we're asking the court to recognize, and again, the court, we're just asking to be able to go back and have our evidentiary hearing in Judge Dozier's courtroom, but his sentence violates the Eighth Amendment at this point because it is so long. His plea bargain sentence has resulted in harsher punishment for his second-degree murder conviction than the Constitution permits him to receive for first-degree murder. That is our argument. It's also, as the court points out, the Booker holding isn't just about the automatic nature of the sentence. It's about the length of the sentence, of a life sentence. It's that a 51-year life sentence the court finds is too long. It's not just that it's automatically imposed, but what the court found was that it is such a long sentence that youth must be considered before that imposition of that long sentence, because that long sentence should be reserved for the worst of the worst.
But I think Booker, the big point about Booker was that it's an automatic 51-year sentence. And the youth of the defendant is not considered.
Yes.
And they said it specifically was for a life sentence under first-degree murder. So, your position is that it makes this expansive change that now every sentence involving a juvenile becomes presumptively unconstitutional because if he entered a guilty plea, the court didn't consider youth?
I don't think Booker goes that far. Booker speaks to the most severe punishments
Well,
that the
this is
state
not the
has.
most severe punishment. The most severe punishment in this case would be life plus 12. And he
Well-
pled, and again, he pled to a reduced offer, and it was the court had nothing to do with it. It was the defendant and the state entering into an agreement.
Yes, he pled to a reduced offer that is still 10 years longer than, and so when we talk about harshest punishment, even the court in Booker speaks to Tennessee, it calls Tennessee an outlier when it comes to the 51-year sentences. But in doing so, if you look at the data that Booker cites, they talk about the fact that in 23 other states, juveniles sentenced to life or life without parole are eligible for release after 25 years. And so Mr. Mason's sentence is disproportionate. It is harsh. It is one of the harshest
The thing is, though, you
punishments.
say it's disproportionate. You know, it's not a situation where, okay, because 23 states say something, this makes Tennessee somehow disproportionate. I mean, again, the legislature sets these. We don't set them. The legislature sets the range in terms of punishment.
But the
And
Booker court did find that the 51-year sentence is disproportionately
If,
long.
well, not necessarily. If the judge had a hearing and determined that this guy had 3 prior killings as a juvenile, then
Yeah.
maybe 51 years wouldn't be too bad. I mean, it says it can be considered. It doesn't guarantee that he's going to get out in 25 years.
Yes, and I agree, but I think Mr. Mason didn't get the opportunity to have that hearing either. And what we are arguing is he is entitled to that. He was entitled to that. The newly recognized right is that with a sentence of 35 years facing that, he was entitled to a hearing in which the judge would consider the circumstances of his youth, and he could not get that. And therefore, we're asking that the court grant the relief we seek. Thank you.
Thank you.
General. Good afternoon. May it please the court, counsel, Will Lundy on behalf of the state. I want to address the petitioner's distinction between rights and holdings. And the petitioner goes to great lengths to talk about the fact that youth must be considered when a juvenile is facing the most serious or the harshest punishments that the state has to offer. The language that the defendant is relying on certainly appears in Booker, but that language first appeared in Miller v. Alabama, which was decided in 2012. We are here on a petition for post-conviction relief, which is time-barred. And the only way for the petitioner to overcome the time bar is to demonstrate that a newly acknowledged constitutional right applies to him. If the rights that the petitioner seeks to rely upon were established in Miller, and let's be clear, Miller established these insofar as the rights, assuming that what Miller is talking about are rights rather than simply the reasoning of the court, those rights were under the Eighth Amendment. It was federal constitutional rights, and they came into existence in 2012. Those rights were binding in Tennessee insofar as they existed. They were binding at the time, and the petitioner didn't raise any sort of a claim in 2012 or 2013, and those claims, insofar as he wants to rely on this language from Miller, is time-barred. And what that leaves is the holding from Booker. And the holding in Booker is, as we've talked about this morning, exceptionally narrow. In Booker, the court held that in juvenile first-degree murder cases, and only in these cases, a sentence is automatically imposed without considering age, and thus Tennessee's automatic life sentence, when imposed on juvenile offenders, lacks the necessary procedural protections to guard against disproportionate sentencing. The defendant here was not convicted of first-degree murder. The defendant, as the court has pointed out, entered into a negotiated and counseled plea agreement with the state for a second-degree murder conviction and the sentence that he received. Insofar as his youth was to be considered, he negotiated with the state, and presumably his counsel and he himself would have been trying to take that into consideration in the negotiating process, and that's something we are not going to look behind. Furthermore, counsel talks about, these harshest punishments. In Miller, the harshest punishment there was in a mandatory life sentence without the possibility of parole. In Booker, the harshest punishment that was considered was this automatic life sentence. So far, neither this court nor the Supreme Court has ever recognized any other sentence in Tennessee to constitute one of those harshest punishments. What the petitioner is asking this court to do is expand Booker, and in fact, not only expand Booker in terms of its scope, but expand Booker dramatically in terms of the relief that it provides. Assuming that the defendant had been convicted of first-degree murder, the relief provided would be this parole hearing after so many years. What the petitioner is asking for now is essentially the opportunity to withdraw his plea and have his conviction completely overturned, which is something that the Booker court certainly never imagined, particularly in light of its statements that its holding was limited and expressly limited in order to protect the state's interest in the finality of criminal cases. Moreover, insofar as the petitioner is arguing that that his plea was somehow rendered invalid or involuntary, and therefore because the Booker court held that this automatic life sentence is unconstitutional, now that makes his guilty plea invalid. The United States Supreme Court rejected that exact argument in 1970. In Brady versus United States, the United States Supreme Court said, "We find no requirement in the Constitution that a defendant must be permitted to disown his solemn admissions in open court that he committed the act with which he is charged simply because it later develops that the maximum penalty then assumed applicable has been held inapplicable in subsequent judicial decisions." Therefore, the United States Supreme Court has held that the petitioner's situation does not implicate the Constitution. The fact that the Booker court held that the automatic life sentences as applied to juveniles who've committed first-degree murder, the court held that was unconstitutional, but the United States Supreme Court in Brady said that does not invalidate a plea agreement where the defendant was trying to avoid that sentence that would otherwise have been held unconstitutional later. That does not void the defendant's sentence. That does not void the defendant's plea agreement. Unless the court has any further questions, I would cede the remainder of my time. I would ask this court to affirm the post-conviction court. Thank you.
All right, thank you, General.
With regard to the issue of waiver, Tennessee, the Booker decision recognized a new constitutional right in Tennessee, and this petition was filed within 1 year of that. There was no saying this need to be filed under Miller fails to recognize that Booker announced a new constitutional right. The Supreme Court of Tennessee acknowledged that in making it retroactive, and Mr. Mason filed his petition within 1 year of that decision. So he has not waived this issue. I would also submit that Mr. Mason doesn't seek to expand Booker. He seeks its application of that newly recognized right to him in his circumstances because it's applicable to him. The court, in fashioning a remedy in Booker, addressed the facts before it, and that remedy does not reach Mr. Mason's constitutional violation. And so he is here before this court seeking to get the remedy that will reach his constitutional violation. In terms of his argument related to his unknowing and involuntary plea, we have no choice but to recognize that Brady exists. And what I can say is that I think it is distinguishable in two regards. First, Mr. Mason's a juvenile. And as we know, juveniles are constitutionally different than adults. And so the fact that he was placed in a position at age 15 to have to make decisions about whether to plead guilty, take a deal, go to trial, That's different and should be considered differently than an adult defendant. Second, the end result of his plea agreement is for him to now be serving a harsher sentence than what he otherwise could receive by law, and that's distinguishing from Brady as well. He did not accept a plea bargain offer that would still be appropriate or legal for him today. It would not. It's a higher sentence than he would have received, than he could receive today, and that's distinguishing.
You're making the assumption that he's not convicted of the aggravated robbery and sentenced consecutively to that, correct?
Correct. Yes. And again, we would ask that this court remand this case to give him an opportunity to have an evidentiary hearing and present his claims more fully and develop a record so that he can bring his claims there and hopefully succeed in trial court on them. Thank you.
All right, thank you. We appreciate the briefs and excellent arguments from both sides, and we'll take it under advisement.
We get two more, I can do one, I can go either way.
Whatever you want to do.
All right, call the next case, please.
State of Tennessee versus Jimmy Uhl.